Hi, I'm Dan Danford, and this is another episode of Money Made Easy for dadsdivorce.com. Had a great question today from the website. I understand that wills and trusts are two different types of estate planning devices that allow you to look into your future and determine how you can protect your children and your assets if something were to happen to you. But I feel like people use them interchangeably, so are there major differences between a will and a trust? Which device is better suited for different scenarios? That's a really good question, especially when children are involved. They are used somewhat interchangeably, but there are some differences. So let's kick through that real quickly. Probably the easier of the two is the will. And everybody knows about the will. One of the things that people don't understand about the will, however, is that this is the instrument that is used to guide through probate. Now, what I hear people say is, oh, I need to have a will so I can avoid probate. That's really not true. A will is actually the document that your beneficiaries or your heirs or your family takes into court and says, here's what our father or uncle or whoever, these are the instructions he left for his demise. Now, the reason why it gets confusing is because, truthfully, most of us don't have assets that are covered by a will. The simple truth is most of us, especially those of us who are married, hold things jointly with another person. So when we're gone, those things become the property of that other person without having to go through probate. So most of us, because we own our cars in joint name and our homes in joint name and our bank accounts in joint name, when we're gone, there's nothing to go through probate. Okay? But the will is important anyway for a couple of reasons. Number one is it catches the things that weren't in joint name. So if it turns out after the fact that there's something that turns up that's in your name, okay, in your sole name, okay, the only way it's going to get where you want it to go is if somebody takes that will into the probate judge and has the probate judge bless it. Okay, so that's important. It catches things that you didn't automatically have in joint name with someone else. Another really important thing is that the will is the document where you recommend to the judge who will take care of your children. Very, very important here. Now, in both cases, in the case of your children and in the case of things that aren't held jointly with others, there are laws saying what happens to them if you don't say. Okay, so what will happen is if you die and you don't have a will, then it'll still end up in probate, but the judge will just go to the state laws and he'll split up whatever, or she'll split up whatever's left according to those laws. And that may be what you want or it may not. Very true of children, okay? You recommend to the judge who you think would be the best person to take care of your children, and in most cases the judge is going to go along with that. Absent that, the judge is probably going to choose whoever they think will do best raising your children, and that may not be your choice at all. You know things about your relatives that the judge doesn't know about your relatives. So this point of nominating a guardian for your children is really, really important. So those are the things. So no matter what, if you have children, you need to have a will. Now, trust is a little more complex device, but it's good for a lot of reasons. One of the reasons is what we see most often is what's called a living trust. And a living trust means that I create this trust and I am going to be trustee of the trust. It's called a self-declaration of trust. Now, anything that's held in the name of the trust, I can treat as my own. I don't even have to file special tax returns. I can buy, I can sell, I can do whatever I need to do. I can file taxes, and the trust exists just kind of in place to be ready if something happens to me. And that's the real key behind the trust, because part of the language in the trust says, I'm going to be trustee as long as I'm willing or able, but if I'm not willing or able, then my successor trustee is X. Okay, and upon that time that I'm no longer able to serve, they step in and they do what I'd like. Now, there's two main things that are important about this. Number one is they can step in the event I become disabled. So I can say, Okay, this is the person I want to look after me financially when I'm gone. And the trust creates that in place. It doesn't have to go before a judge, doesn't have to anything happen. They just take over when I'm no longer able to do it. The second thing is I might have provisions in that trust that say after I'm gone, okay, say there's $100,000 left over and I want part of that to go to each of my children. But I may not want it to go to each of my children that day. I may say, especially if my kids are fairly young, I may say, you know, I want the trustee to manage this money for them until they turn age 30 and then give them the money, okay? So the trust can live on even after you're gone. Now the will, all it's going to do is distribute stuff to those people when you're gone or through the court, but it isn't going to go on after that, and the trust really does. As to which is better for your circumstance, you really need to sit down with an attorney or you know, you'll have to sit down with an attorney to have the instruments drawn anyway. But they can help you figure out which one is best suited to your purposes. The will is simpler, and for many people that just works very, very well. But for people who have special needs or a lot of assets or unusual things that they want done with their assets after they're gone, the trust just works perfectly. And the good news is neither one of these are just ridiculously tough to set up. Okay, so we aren't talking these are going to cost you tens of thousands of dollars to get them in place. A good attorney will be able to do one or both or all the instruments you need and not charge you an arm and a leg. Really is a good question. It really is important for each family. So I'd suggest that if you don't already have will, trust, or will, go visit your local attorney, tell them what you need. They'll walk you through the process and they'll get you all set up. Won't cost you a lot of money, but it'll give you a lot of peace of mind. That's it for another episode of Money Made Easy for Dad's Divorce. We'll see you again next week. Thanks.